Welcome you to lesson number 42 in our 50-part series on the law of evidence. In today's lesson, we will see the situations, the exceptional cases in which secondary evidence may be given. As you know, secondary evidence can be given only in the exceptional cases as stated in section 65. Before we get into the lesson, I want to remind you a couple of things. The first is that with regard to a document, you must remember that there are two things in relation to a document. The first is what is contained in a document. The second thing is other things about a document, whether the document exists or not, whether the document is torn, whether the document is in good shape, the color of the document, and all of these things. Okay, so there are two things. The first, the contents of the document, the material that is actually in the document. And then there are other aspects and attributes of the document, and these two things are quite distinct. For example, when you look at section 59, which basically talks about oral evidence, it says that oral evidence can be given for everything except the contents of a document, which means that oral evidence can be given for other aspects of a document. Okay, so it's important to have this distinction clear in your head. Also, we have seen that as far as the proof of the contents of a document is concerned, it can be proven either by primary, which is what section 61 tells us, either by primary, and primary basically is given to us in section 62, or it can be proven by secondary, which is given to us in section 63. However, there is a rule, the rule being that primary is preferred, right? Which means that you go for the primary evidence only unless there are some exceptional situations. This point is given to us in section 64. And then the exceptional situations in which you can go for secondary evidence is given in section 65. So in today's lesson, we will have a look at section 65 and identify those exceptional situations in which you can offer secondary evidence. Now, have a look here at sections 64 and 65 and also see if this little information that we saw in the beginning of the lesson fits in, whether it helps you in some way. Just look at these two and see whether this helps you in some way. Take a moment. I'd suggest that you pause the video to get an idea of what I'm trying to say. Whether this detail here helps you in some way in looking at some of the details in section 64 and 65. Okay, so when you look at section 64, it says documents must be proved by primary evidence. It does not say what about the documents. It just says documents must be proved by primary evidence. When you look at section 65, it says secondary evidence may be given of the existence, condition, or contents of a document. So here you see contents of a document and you also see other things. So let's say when you talk of the existence of a document, whether the document exists or not. Condition, the condition may be that maybe it's torn, maybe it's tattered, maybe it's in good condition, maybe it's with someone, maybe it's with someone else. So you see, these are various aspects and attributes of a document. Now, when you look at section 64, is it talking only about the contents of a document when it says here? Or is it talking about all of these things put together? It's very clear in section 65 that it deals with all of it, right? Contents as well as other things. But in section 64, I ask you, is it dealing only with the contents or is it dealing with other things as well? Okay, since it has not been specified that it is only for the contents, you must understand that by document here, it refers to everything, both the contents as well as other things. What that means is that ordinarily, even the existence condition of a document should be proven by the document itself. So let us say I want to say that, okay, there is a document. That means I want to prove that the existence of a document. Okay. How do I prove it? Prove it by the document itself. That's what original is, that's what primary is. So when I want to say that the document exists, prove it by the document itself. If I want to say, okay, the document is in bad condition, how do I prove it? Again, do it by the document itself, which is primary. If I want to talk about the contents of the document, how should I do it? Again, do it by using the document itself. Okay. Now, let's say instead of proving that the document is there, which I can prove by showing the document itself, suppose I want to prove that the document is not there, which means that I now tell the court that there is no such document. So let's say A and B are the parties. B says that there was a contract. Okay. A says there was no such written contract between us. So he wishes to say that there is no such contract, or he wishes to say that there was a certain term in the contract which he does not agree with, that there was no such term. Can he prove that by the document itself? Can you, when you're saying that there was no document, can you prove that by primary evidence? You cannot. And that is why in some cases you need secondary evidence. Okay. So let us say A is saying that there was no document. Can he show a document, or can he show a copy of that document? No. Right. So we will look at some of the cases in which secondary evidence can be given. Just think about it first. Ideally, we want primary, which means we want the document itself. But in some cases, it is neither possible, or maybe it is not practicable, it is not feasible, and therefore secondary evidence is permitted. Now let us look at section 65. It's a long section, so I'll scroll you through that so that you can get an idea of what is given in section 65. So we will see in section 65 the various cases in which you can see secondary evidence is permitted. Okay, so basically this will deal with cases in which it is hard to get the original. So looking at our first example here, subsection A. When the original is shown or appears to be in the possession or power, look at the first bullet point, of the person against whom the document is sought to be proved. So let us say A and B are in dispute, okay, and there's a certain document that B wishes to prove to the court. Okay, now the original of this, let us say the original is actually with A. Do you think B can get the original from A? Obviously not. A will not give him the original, right? So when the possession is with the person against whom it is sought to be proved, B cannot get the original, and therefore the court will allow him to get a copy, and therefore secondary is permitted. I hope you get the point. Going further, of any person who is out of the reach or not subject to the process of the court. So let us say somebody has gone beyond the jurisdiction of the court. Process of the court means summons, warrants, etc. That's what the issue of process is. So if somebody is beyond this process of the court, then again getting that document from him is not possible. So you allow a copy. Also, it can be of any person who is bound to produce it, but despite the notice that is given to him under section 66, he does not produce it. So let us say A has the original, he is bound to produce it. He sent a notice, please bring me the document, but he still does not get it. Then again in this case, you allow secondary evidence to be given. Okay, so you can understand as to what is happening in here. So let us scroll this further down so that we can see what we have here. It's fairly simple. Okay, likewise you can see in B that when the existence, condition or contents of the original have been proved to be admitted in writing. Okay, so the original has already been admitted in writing. Okay, so then you can have that. Then when you see when the original has been destroyed or lost, so when you don't have the original, obviously you can't show it. When the original is such that you cannot easily move it, or when the original is a public document, then in such cases obviously it's hard to get the original, and therefore you allow for secondary evidence. Okay, also when you see, look at F and G, that the original is a document of which a certified copy is permitted. So if the copy is permitted, you can give the copy. then you see the original consists of so many parts, numerous accounts or parts, that it is not possible or convenient for all of them to be examined. So you say that, okay, just give me the general result. Instead of showing everything individually, just show me the general result. Now, if you see these things here, cases A, C and D. In the cases A, C and D, you can give secondary evidence. In the case B, you can give just the written admission. Okay, you can see what the written admission was, that when a person has given in writing an admission, then you can give just the written admission. Let's have a look back here. So you see, in the cases A, C and D, you can give secondary. In the case of B, here you give this admission in writing. That's what we just saw. Okay, we scroll back and then we see that in the case E or F, where a certified copy is permitted, you can give a certified copy. And in the case G, when you said the general result, so let us say there were, let us say in like for example, let us say your internal assessments. Let us say I had taken 20 internal assessments, each of 1 mark. Okay, so the total is 20 marks. Now the question is basically the general result. The dispute is whether you passed or failed. Okay, so I'm not necessarily concerned with how much you had in unit test number 1, unit test number 2. All I want to know is that out of these 20 tests, did you manage to get a total of 10? Okay, so we are concerned with the general result and not each of the individual things. So in the case of G, evidence may be given as to the general result of the documents by any person who has examined them or who is skilled in the examination of such documents. So maybe let us say as a person who is, I wouldn't say skilled, but who has to evaluate these papers, I pretty much have an idea of who has got 10 out of 20. So if the court cannot see all of these 20 assessments, maybe I can just tell the court that, okay, this person has passed, this person has more than 10, so this person is passed. Or I can say this person would have got less than 5 or even less than 2, so this person has failed. So a general report can be given as far as all of the documents are concerned. So I think it's quite clear as to what is contained in section 65 when you go from A till G, and with that you get an idea of the cases in which secondary evidence can be given. So with this, we've pretty much seen the entire matrix of how oral evidence and documentary evidence are related. So I'll just quickly take you through sections 59 to 65 once so that you get an idea of how it works. When you look at section 59 and 60, it deals with oral evidence. Okay, so oral evidence can be given for everything except the contents of documents. For the contents of documents, we have primary and secondary. 62 talks about what primary evidence is. Then we have section 63, which talks about what secondary evidence is. Then we know that we have a preference for primary evidence, which is given in section 64. And then now in section 65, we saw the cases in which secondary evidence can be given. Okay, and as you know, the provisions following this 65A and 65B deal with electronic records, and we shall see them later. So I hope that this lesson was of some use to you. Thank you so much for your patience. I wish you a good day. All the best.